We're now going to start by hearing what it is you're all talking about this morning. And David Farrell is going to take us through he and the team have been working over lunch to pull together a set of slides which hopefully captures what it is you were talking about this morning. David.
Thanks, Tom. Right, so with all the warning notes that we normally apply, this is the best attempt that Leah and Clodagh and I had to try and summarise on 4 slides the gist of your conversation. So we have notes, more detailed notes, that will go into the final report. This is just an attempt on these slides to summarise the main points before you have a bit of a discussion about them. So the first slide is on arguments for leaving the Constitution unchanged, the existing Constitution clause unchanged, and I'll quickly talk you through these. It protects religious beliefs for all religions, not just one religion, so it doesn't discriminate. It's an important deterrent against disrespect of religion. To remove it would give a signal of religion being downgraded. Religion is different from other things, it's more personal, so it needs to be protected. Ireland is becoming multicultural, so you need to respect the beliefs of all religions, the new religions. And then a slightly different version of that, we need to protect religious minorities in Ireland, whether newly arrived or who have already been here before. Having the clause prevents radicalism. It doesn't offend anyone to keep it. The preamble to the Constitution that has been raised a few times already today leads logically to something like this. It makes people think before they act or speak. We should keep the status quo until we see how the future unfolds. And then finally, the Constitution gives higher protection than legislation. So it's worth keeping it in the Constitution. Then arguments in favour of removing the clause or in some way or another amending it. One argument, it overprotects the religious groups. It particularly ignores the position of non-believers. We need to recognise that our society is modernising, it's secularising, so we need to update our constitution to reflect that. It is unusual to have a crime like this in the Constitution, and indeed unusual to have crime mentioned in the Constitution, something that was raised in this morning's presentations. It's vague and it's unworkable. We heard that as well this morning. And then owns modest wording. There were a couple of specific points from at least one table about this, so that we use owns draft as it is, or we use owns draft and add a specific reference to religion, or we use owns draft and add a duty to the state to legislate against, quote, hate crimes. And then 2 final points. Legislation is sufficient as it is. Or a slightly different variant of that, we should enhance other legislation to make it stronger, in particular relating to hate crimes. So they're points for and against constitutional reform. But as you'll have heard, particularly in Owen's presentation this morning, there's a somewhat related question on the Section 36 of the Defamation Act. So this is now looking at legislative proposals for legislative change, quite apart from your views about constitutional change. So first of all, arguments for just keeping Section 36 as it is. It protects all religions. That's a sort of variant of what you already heard relating to the Constitution, so it's not discriminatory. It protects people from being grossly offended, though that particular phrase was used by one table. It is clear and it protects people from having their beliefs trampled on. We should only retain it if the constitutional prohibition on blasphemy is retained. So a specific link, if we're going to keep the constitutional clause as it is, then we should keep the legislation as it is. There was one table that made the point that it's ineffective, but we might as well leave it alone. And then finally, it is basically good, but it could be amended to make it more effective. And then final slide, arguments for deleting or amending Section 36 of the Defamation Act. Broad agreement at a number of tables. So this particular point came up quite strongly from quite a few tables here, that it should be either amended or deleted. Without going into details, just a strong expression from a couple of tables there. It's vague, it's ineffective. That's the counter argument to what you had in the previous slide. So we might as well delete it or change it. It's already covered by the incitement to hatred legislation, or indeed more widely in other legislation. And then finally, why is religion more important than other aspects of our lives? So why should we single out religion for protection in the legislation? So they're the 4 points, 4 slides.
David, thank you very much. We have about a half an hour now to, if you like, for people to comment or ask questions. We have our experts who are here this morning still with us, and if necessary, so if some of the questions that are raised, they will be available to answer them. So who would like to kick off? Bit unusual. On any, yeah. Okay, Angus, please.
It's just a question, maybe the experts might be able to give a small presentation just of what is exactly covered in the incitement to hatred acts that currently exist in the state, kind of so that people would understand whether there's enough protections or a lack of protections.
Okay, that's a useful thing. We'll, yeah, perhaps Neville or Owen at the back there.
Thanks very much. Incitement to hatred legislation, I think it's relatively ineffective. It makes it a crime to, and it's intentionally to stir up hatred in respect of someone on the basis of race, religion, gender, sexual orientation, member of the travelling community. I can't remember the listed grounds under equality legislation generally. What you have to prove is complicated under the legislation. You have to prove that it was, I think, likely or capable of stirring up offence, and it was intended to do so. As far as I know, and Owen may be able to correct me on this, there've been the most notable case where this happened was where a bus driver had got into a fight with an African American chap on a bus and used the unfortunate phrase, "Get off the bus, nignog." And there was outrage at this, and he was prosecuted under incitement to hatred legislation, convicted in the district court, but on appeal, the conviction was overturned in the circuit court on the grounds that there was simply no likelihood that what he had said would actually stir up hatred against anyone other than himself. In other words, it wasn't going to stir up hatred against the African-American guy on the grounds of his race. The bus driver apparently had threatened to throw a cash machine at him and stuff, so there would have been a level of distressed mind there, I think would be the charitable way of putting it. But the reality of the situation was, I think this showed up the legislation because it's not something which targets expressions of racism. It I think effectively targets a situation where someone publishes something which is convincing and which is presented in such a way that it could genuinely have the effect of stirring up hatred. In the blasphemy context, the fact that someone publishes cartoons which are offensive to a community, or publishes a book which is mocking a religion or whatever, it may be deeply offensive to people, but it's, I don't think, going to satisfy the burden of showing that it's capable of stirring up hatred against the group whom it's mocking or whom it's offending.
Okay, thank you. Any other comments or what you've seen from David's 4 slides, which is their best effort to capture what has been said at the tables this morning? Yeah, or comments, observations. Yeah, Catherine.
I know that one of the
Again,
first...
just Catherine, your name,
Sorry,
please.
I'm Catherine Riley. One of the arguments there is that it protects religious beliefs for all religions. I was wondering if the experts could just maybe talk about Article 44 and the protections that are there currently within the Constitution for protecting religious beliefs.
Okay. You're going to have to be paid overtime for this. Owen again, or Neville, are you taking that? Microphone beside you there, yeah.
Sorry, could you just say the question again? I'm so sorry. Okay, I mean, there'd be fairly substantial protection for religious freedom and for religious groups generally within the Constitution. I suppose Where it's proved slightly controversial is in terms of the definition of what is a religion in this respect. But I would suggest that for all sorts of reasons connected with obligations under the European Convention and indeed under EU law generally, it would be necessary for the definition of religion to be a broad one. What the Defamation Act does is interesting in terms of the blasphemy clause, in the sense that it says that it applies to all religions, but it excludes those who are there to make profit or who engage in psychological manipulation of devotees, which, on one level is the definition of a religion. But I think it would be aimed at dealing with certain cults, one would suggest. So I would suggest that probably now, if the matter came before the courts, the concept of religion would be given a very broad definition. And there's no doubt that the Constitution as it stands provides a very firm protection for religions and for freedom of conscience and for freedom of belief, as also does the European Convention.
Okay. Very clear answer, I think. Okay. At the back here, please.
Thanks very much. David is my name. It's not so much a question for the experts, more a general comment or a query to the floor. But I was just wondering there the bit that it doesn't discriminate any religion and it protects all religions. Could it be argued that in fact, when taken with the Catholic character of the entire Constitution, that it doesn't? It defends Catholicism over other religions. So for example, could someone of a different religion, a different faith, say, well, I disagree that your Christian Catholic God is not the real God, my God is, and could that be construed as blasphemy? I know it's a kind of a theoretical and extreme case, but I just thought it was worth saying.
Okay, well, it may be a comment, but in fact it may also be a question. So, Neville, would you like to comment on that?
I love microphones. First of all, I would actually reject the notion that the Constitution is an explicitly Catholic Constitution. I think it's an explicitly Christian Constitution. Second of all, would that constitute blasphemy? Absolutely not. Under the 2009 Act, it simply couldn't. I don't think, in any event, since about 1700, it would have constituted blasphemy even in common law, in the sense that saying, respectfully, I think your God is wrong, or simply saying, look, there is no God, and therefore the kind of Richard Dawkins approach of saying this whole religion thing and belief in God is complete, absolute nonsense. That absolutely wouldn't be, in any sense, I don't believe, a crime of blasphemy for centuries. But I mean, the 2009 Act absolutely makes it clear that it for two reasons, it couldn't constitute blasphemy. First of all, because you wouldn't be able to prove that the intention was to cause offence. And second of all, because any reasonable observer would say that it had a genuine political merit to it.
Okay, thank you. Michael.
Just a quick question. Could a religious right itself be caught by the Blasphemy Act, in particular sort of a prayer for a perfidious, the expression in the Good Friday rituals, which there's a lot of debate over within the Catholic Church, and this prayer for perfidious Jews as has given rise to a lot of debate. Could that be actually prosecuted under the Blasphemy Act, theoretically?
I didn't know that prayer, but that's cool. No, it couldn't, again, because you wouldn't be able to prove that the intention behind it was to cause offence. The intention behind it is to pray, presumably, for the redemption of lost souls, right? And second of all, because, again, it would undoubtedly have a reasonable merit beyond causing offence. So I would have thought, in those circumstances, what you might be looking at is a sort of an analogy with what the Westboro Baptist Church do these guys in the States who protest at funerals because they're opposed to homosexuality, and they have the God Hates Fags logo, and they go, and it's kind of strange logic that the reason why American servicemen are dying abroad or homosexuals are dying at home is because it's punishment from God. So these guys protest at funerals so that the parents of people who have been who are grieving the loss of a child can be exposed to the screams of these guys that God hates their child because he was homosexual, or hates America because it tolerates homosexuality. I would have thought that something like that, where the stated intention of the group is to cause offence, that's the sort of thing, if you could apply that to a blasphemy context, that's the sort of thing that might be caught by the 2009 Act. The defence, though, would be that it has a genuine, albeit incredibly unsavoury political merit to it, and therefore should be caught by the defence in Section 36. But to be perfectly honest, I find it very difficult to conceive of a single situation of publication which would satisfy both wings of Section 36 and could then be prosecuted.
Okay. I mean, a lot of this seems to suggest that, you know, under the current 2009 Act, the chances of a significant number of court cases is actually very limited.
I think that's true. I said this to a couple of tables. I mean, there hasn't been a blasphemy prosecution in Ireland since 1855. It's not like this is something that you could build a career on as a practitioner. So that's the first thing. The second thing is that probably the most significant change which the 2009 Act made to the previous situation is that you can no longer have a situation where there's a private prosecution for blasphemy. And as I said to one table, I would have thought the biggest fear for someone in the previous dispensation, a publisher or a journalist or whatever, is that you could have some randomer with too much time in his hands seeking leave to bring a private prosecution, going to the High Court. The defendant newspaper, let's say it's a newspaper, has to defend itself, has to get a solicitor and brief counsel, is going to accumulate legal costs for itself, will probably win the case, will probably get its costs, but because of the impecunious nature of the applicant, may not be able to recover costs. And I would have thought that in practical terms, that was the big sting, potentially, of the previous law, that you could end up accumulating a significant cost bill that you're never going to recover from this guy because he's taken your time up by bringing a really fairly sort of farcical private prosecution or application for leave to bring a private prosecution. You can't do that now. In other words, the only prosecutor now is going to be the state. And with all due respect, apart from the theoretical terms of the legislation, like the police really aren't going to be in the business of bringing private prosecutions for, or bring public prosecutions for blasphemy, save in the most extreme circumstances, and save where they're confident, and the DPP is confident that it's going to actually win. And I don't think the DPP could be remotely confident in virtually every case that there would be any chance of success. So I don't think you're going to see any prosecutions under this legislation.
Okay. Okay, any other comments? Yeah, Ivana, please. Mary, Ivana, thanks.
Thanks very much, Mary. And just Ivana Bacik, and just following from what Neville has said, and I don't disagree with him. In fact, when the minister, who was Dermot Ahern at the time, was introducing the Section 36, he more or less intimated or suggested in the debates that he didn't think it was going to be used as an offence, which does you know, in terms of criminal prosecutions, which begs the question why it's in the law in the first place. And I suppose just to say, you know, I don't think it's utterly hypothetical, though, to say that there could well be a prosecution in the future if, and particularly if, somebody was to, or some organisation was to seek to provoke a prosecution by publishing something that they knew was likely to cause outrage. So it certainly doesn't rule out that sort of incident or prosecution in the future. And the question then is whether that's, the, you know, along the lines of the satirical magazine in Denmark that published the cartoons we spoke about earlier. And in that sort of instance, certainly Section 36 could well be activated by, again, it would have to be by the DPP, by the state. So, you know, it isn't utterly hypothetical, but at the same time, it was interesting that there was no real justification offered for introducing the legislation in 2009, or for introducing Section 36, and the Minister himself seemed to suggest he didn't think it was going to be workable. You know, it's a rather circular point. If it's not workable, why do we have it as an offence if it's not there for any particular reason? The only possible scenario one could envisage it being used is where somebody is seeking to provoke a prosecution. And then the question is that the sort of thing that our criminal law should be used for, to provoke that, you know, a sort of satirical publication like that?
Thank you. Amy, could we have the mic up here? Robert, please.
Robert Dowds, Could I just get a reaction to a view I have about Article 40, the section that we have on this sheet here, which basically says the state guarantees liberty for the exercise of the following rights subject to public order and morality: the right of the citizens to express freely their convictions and opinions. Would that not be adequate and just delete all the rest, because it goes into detail to do with blasphemy and also in terms of the state trying to ensure that the cinema doesn't show something that's inappropriate and so on. But if it was simply the state guarantees liberty for the exercise of the following rights subject to public order and morality: the right of citizens to express freely their convictions and opinions. And would it be better if the word public order was simply subject to law, because that then ties it in with what's actually passed by the state? I'd be interested in a comment on that from the experts. Thanks.
Okay, Neville obviously doesn't like the microphone all the time. He does funerals, weddings, bar mitzvahs. He's got a good stand-up and song and dance routine, but he's tired. So I'm going to take this one. Three quick answers. The right of citizens to express freely convictions and opinions has been a controversial phrase because it's capable of being interpreted very narrowly. There's an awful lot of speech, there's an awful lot of expression, there's an awful lot of conduct that isn't just convictions and opinions. Artistic debate, statements of fact, scientific discussion is not about convictions or opinions. And therefore, that particular clause has caused difficulty in the past. The Supreme Court has indicated that it will see it as a generic free speech clause now, but it took 40 years of litigation to get to that point, and it's still not stable. So that particular clause is problematic. Making it subject to public order and morality and nothing else, there's a whole range of reasons why you might want to have legitimate restrictions upon speech or upon any right. And public order and morality are only two. Article 10, subsection 2 of the European Convention has a relatively long list. And having only two probably is not allowing for the full and proper range of legitimate restrictions. And then the third point is you tried to accommodate that point by saying the state guarantees exercise subject to law of the following right: the right of citizens to express freely convictions and opinions. That wouldn't prevent a state introducing a law that says, okay, you can't say anything. Because if you say it's subject to law, then you allow the law to do whatever you want. The whole point about the Constitution is to set down the legitimate parameters. Not to fudge the issue or to allow the legislation to say whatever it wants. So if you're going to do major surgery to 46.1.1, I will go back to my modest proposal. There's a clear statement of the right comes first, because rights are prior, and then a clear statement of the grounds upon which rights can be restricted and the basis upon which that restriction can happen. So if you are going to do radical surgery, the surgery that's just been suggested, to my mind, wouldn't be sufficient. In part because the definition of convictions and opinions can be narrow, in part making the right subject to the exception gets the cart before the horse. Thank you.
Thank you. Yeah, Deirdre, please. Thank you.
Hi, Deirdre Donaghy. Could I just ask, does interpreting the Constitution as it stands, does it have to be done in conjunction with Article 30, is it? Or could somebody say, well, Section 36 of the Defamation Act, or could somebody say, well, I think I've been defamed, not within that, but kind of more generally blasphemed, and could they challenge Section 36 on the basis that it isn't fully what's in the Constitution if we leave the Constitution as it stands?
Neville, you got that question? You got the precise...
Yeah, what you're saying is if someone claims that they're the victim of blasphemy and the only ground for prosecution is Section 36, could they say that, in fact, their constitutional rights, or at least if the Constitution stays the way it is, that the constitutional rules on blasphemy aren't being properly respected because the section is drawn in excessively tight terms? Yeah, that's a very, very interesting question. Theoretically, it's possible. I mean, the legislation is subject to constitutional obligations, and therefore the legislation is unconstitutional. It can be challenged. I would think probably that the response from the courts would be to say, well, the Constitution doesn't require the nature of the crime of blasphemy. It simply requires the existence of it. The statute tells us that the crime exists, therefore it's doing the constitutional job. There's nothing in the Constitution to say it must be sort of framed, the crime of blasphemy must be framed in these terms. And also there's no right in the Constitution, I think, there's no right not to be the victim of blasphemy. I don't think that blasphemy offends against a right to freedom of religion or a right to freedom of conscience. But I think that's a very interesting question. I'm going to think about that. Thank you.
So maybe if you, having thought about it, want to come back further to at the very end, we'll take that further comment. Okay, there's any other comments, questions? Okay, yourself. Okay, thank you.
Alan Green's my name. I'm just wondering if any of the experts could give us an overview of other developed countries where legislation has been introduced recently to cover blasphemy, or are we the exception here? As far as I'm aware, we are, but I just wonder if we could get clarification on that. And also, I know there's been a couple of cases in recent history in the last 2 or so years where other countries have pointed to Ireland and its introduction of blasphemy legislation as justification for their own rather harsh punishment for blasphemy. And I was just wondering if there's any comments on that as well. Thanks.
Okay, two different questions. The first one, what do other countries do? I put a slide up and I've got it reproduced in the materials that I prepared. 45 countries in the Council of Europe all do something. There is no country in the Council of Europe that doesn't have some kind of blasphemy or protection of religion or incitement to religious hatred legislation. And even countries like Sweden and Denmark, where multiculturalism and liberalism have an impact, do still have protection of religion legislation, though not necessarily very broad protection. But the point is that everybody else in Europe is doing something similar. The most accessible of the recent changes is the UK change, and that's provided in my my handout as well. The second point is the law of unintended consequences, and sometimes perhaps the law of unintended reporting as well. It came as a shock that there were international reports that countries such as Pakistan had referred to the Irish 2009 Act in making arguments in favour of defamation of religion declarations in the UN. As I was standing up to come up and answer the question, Neville actually told me that that's a misreporting. That in fact didn't happen, but because it's such a good story or such a bad story, depending on your point of view, you're not letting the facts get in the way of that story. I think whether it happened or not, the fact that it can credibly be reported that it did demonstrates the unintended consequence of giving effect to Corway. All right, thank you.
Thank you. Richard, David.
Can I just ask, sorry, Owen, can I just ask for clarification? Maybe it's just me being daft, but in relation to your answer to the first question,
yeah.
If we found that the convention was to vote to remove the blasphemy clause, section 36 of the Defamation Act altogether, would that mean that Ireland then ceases to have an entry in the box, or would we still be in one of the boxes in your comparative analysis for other reasons?
Yeah, we would, because the word religion appears in the incitement to hatred legislation. Now, our incitement to hatred legislation, as Neville demonstrated, is actually quite narrow, which is why the UK, which had a similar piece of legislation, expanded the range of racial and religious hatred in 2006. But even if we were to remove it from the Constitution and remove it from the Defamation Act, we would still have an entry under prohibition of incitement to hatred, because religion is one of the protected grounds in that Act.
Okay, thank you. John?
Thanks very much, Tom. John Lyons. I suppose I was particularly taken back in a positive way by the comments of Maeve Cook earlier on today from UCD, and that kind of philosophical approach. And if I could just drag it back to there for a second. And, you know, what struck me about what Maeve said was that, you know, if we take our constitution, as I'm kind of mixing a couple of people's things, but the last comments will be kind of based on what Maeve said. If we take, you know, the concept that our constitution is a set of guiding principles, which ideally should be about how the individual, to use her phrase, flourishes as a human being, or human flourishing, that those guiding principles should allow every single citizen within that country to flourish to their best potential, to be the best possible person that they can possibly become. And if there are any obstacles in that way, perhaps in the guiding principles of our constitution, we prevent society from becoming the best possible society that it can become. So the question Maeve asked, and I thought it was a really, really important one, is there a place for blasphemy within the Constitution, given that, you know, should the Constitution be a set of guiding principles that respects everybody, the fact that there are people beyond, you know, particular religions or none, and therefore by imposing you know, a part within the Constitution that identifies, you know, a set of beliefs that are crucial to some, but by virtue of not including the fact that there are some that have no beliefs, you know, are we going back to that concept of human flourishing? And are we saying that, you know, in a philosophical way, without maybe in a, you know, in a legislative way, but in a philosophical way about the type of country, the type of republic that we want to have, that perhaps some are more important than others? And would it be best then, if this is our guiding principles, in order to guide the type of society that we want to grow, a republic where people are all the same, is it right that we have the word blasphemy within our constitution, given that it makes reference to some and leaves others out? And if we do want everybody to flourish, to become the best possible person they can be, should we have obstacles in their way in the Constitution, because that contradicts what we as a society then want? That's my soapbox over. Thanks.
Okay, all right. I mean, I don't know whether Maeve wants to comment on that, because, I mean, I think he's broadly supporting what you said this morning, so, okay.
Thank you. Yeah, I mean, well, he is broadly supporting. Thank you, John. What I said this morning. I don't think I said the Constitution was a set of guidelines, but I think one could think of it like that as well. I said philosophy offers guidelines, but I think that, you know, it fits the Constitution. The point I'm making about blasphemy, and having listened with great interest to the presentations this morning and the comments from the floor, and I'm not an expert in this at all. My difficulty with blasphemy is that it's an offence against God. It has become perceived as an offence against religious believers, but in fact, blasphemy is an offence against God. It offends religious believers because it's an offence against God. And I can't see how there is room in the Constitution, which has to, I think, accommodate possibilities for human flourishing for everybody, for an article that presupposes such a strong commitment to belief in God, which doesn't mean at all that religious sensitivities shouldn't be protected constitutionally, or there aren't other statutory and legal ways of respecting and safeguarding people's religious sensitivities.
Okay, thank you, Maeve. We probably have time for one or two more comments, and then we'll be moving on to the section on what we're calling external perspectives, and I'll introduce that in due course. Rona.
Thanks. Hi, Rona Farrell. I just want to pick up on one thing there, that blasphemy actually isn't an offence against God alone. It's against God, a God, or sacred things. So it's not definitely about God. It's covering anything that's sacred to people. So in that sense, it's covering, if you're a non-believer and you value that, then that's protected as well, because that's sacred to you. And if you really want people to flourish, what about the people who flourish through having a protection against their beliefs being picked up and the detrimental things that are said about religious? But just to reiterate the point, it's about God, a God, and sacred things. It's not a specific God, a specific religion, or a specific ideal.
Thank you. I suspect maybe either Neville or Owen might want to comment on that. But are there any other comments now? Because we'll be wrapping up very shortly. If there are none, well, I mean, do either of you want to comment on that last comment? Owen doesn't anyway. Do you, Neville? No. Okay, fine. Well, it looks like, I was going to say Brona had the last word, but maybe Ivana might have the last word.
I don't want to be too sorry, Ivana, but I don't want to be butting in again, but it's just that in section 36, it does clearly state the definition of blasphemy is in relation to matters held sacred by any religion. So it doesn't cover matters held sacred by persons who don't believe in a religion. So just to clarify the definitional point.